My name is Wendy.
And I'm Marie, and we're parents who went through the child welfare system in Colorado not too long ago. I understand this may seem overwhelming for you right now.
It is very normal to be feeling confused, angry, or afraid. However, the information you're about to hear is very important, so please make sure to listen carefully to the advisement on this DVD.
Hello, you're here for a temporary custody hearing, also referred to as a preliminary protective proceeding or shelter hearing, because the Department of Human Services has alleged that your child or children are dependent or neglected as defined under Colorado law. The purpose of this video is to advise you of your rights in dependency and neglect cases, inform you of the possible options the court has if your child is found to be dependent or neglected, and to advise you of the consequences of your failure to comply with your treatment plan or any other court orders. There will be a number of people involved in your case. A guardian ad litem is an attorney who will be appointed by the court to represent the best interests of your child or children. The county or city attorney represents the Department of Human Services and is responsible for proving the allegations that your child or children are dependent or neglected. The caseworker works for the Department of Human Services and is responsible for investigating your case and making recommendations as to what services need to be provided to you and your children in order to ensure their safety. The attorney who represents you in these cases is called a respondent parent's attorney. In some cases, a volunteer called a CASA, which means court-appointed special advocate, will be appointed to assist the child or children, family, and the court in determining what is best for your child or children. There are some very important things you need to know about dependency and neglect cases. The law requires that you be advised of these rights. These are your rights. You're not being charged with any criminal offense in this proceeding. Dependency and neglect cases are civil cases to ensure that your child or children are safe and to assist your family in providing a safe home environment for you and your children. You have the right to have an attorney represent you at all stages of the proceeding, including any appeal. If you cannot afford an attorney and you financially qualify for a court-appointed attorney, one will be appointed to represent you at no cost to you. You will be given an application to fill out to determine if you financially qualify for a court-appointed attorney. A petition will be filed with the court that states why the Department of Human Services believes that your child or children are dependent or neglected. The allegations contained in the petition will be reviewed with you by your attorney or by the judge or magistrate during your court hearing. You have the right to deny any or all of the written allegations made by the Department of Human Services and require that those allegations be proved by a preponderance of the evidence at a trial. A preponderance of the evidence means that the evidence must show that it's more likely than not that the allegation is true. You have a right to have a trial before a district court magistrate, a district court judge, or a jury of 6 people from your community. If you decide you do not want to have a trial, you may waive your right to a trial and enter an admission to any of the allegations against you contained in the petition. If you admit one or more of the allegations in the petition, your admission must be made freely and voluntarily. Your admission cannot be the result of any undue influence, coercion, pressure, or promises on the part of anyone. You must not be under the influence of drugs or alcohol at the time you make your admission. If your case goes to trial, you have the right to cross-examine the witnesses against you, call your own witnesses, including expert witnesses, present evidence, and testify on your own behalf. You have the right to use the subpoena power to require witnesses to appear in court to testify. If either the court or the jury finds that your children are dependent or neglected, you have the right to appeal that decision. If you decide to have a trial, your trial must be held within 60 days if any of your children are under the age of 6, or within 90 days if none of your children are under the age of 6. If you win at trial, the case will be over and your children will be returned to you if they are not already in your custody. If you lose at trial, or you have admitted to one or more of the allegations contained against you in the petition, the court will do any of the following. The court will adjudicate your child or children to be dependent or neglected, which means that the court will have jurisdiction or authority to enter orders that will impact you and your children. The court may place your child or children in the legal custody of one or both parents, with a relative or legal guardian. The court may place your child or children in the legal custody of the Department of Human Services for placement in a foster home or child care facility. The court may also order the child to be examined by a physician, surgeon, psychiatrist, or psychologist to receive other special care or be placed in a hospital or other suitable facility. There are also some other important things you should know. You must complete a relative resource information sheet within 15 days from today's date. You must list the names, addresses, and telephone numbers, if known, of any grandparent, aunt, uncle, brother, sister, or other relative of the child or children. Your failure to provide this information may result in your child or children being placed permanently with someone other than your family or family members. The court has the right to place your child or children with someone other than you. If the court decides that it is necessary to place your child or children, the court will first try to place your child or children with a grandparent, aunt, uncle, brother, or sister. If none of these relatives are suitable, the court will try to place your child or children with any other relative if such placement would be appropriate and in the best interest of the child. If you or any of your children have any Native American or Indian heritage, please let the court know, because more protective laws may apply to people who have Native American Indian heritage, such as a higher burden of proof before a child can be found to be dependent or neglected, or your parental rights terminated. Also, notice of these proceedings must be given to the tribe and the parent or Native American Indian custodian. If it's found that your child or children have Native American heritage, the court may have the option to consider placing your child or children with a Native American custodian. The court is not bound by any promises or representations made by anyone as to which of these placement alternatives the court will select for your child or children. Now I'm going to tell you about the treatment plan and what that means. If you admit to one or more of the allegations, or you lose at trial, a treatment plan will be devised to address the problems that led to the dependency and neglect case being filed against you. You have a right to participate in the creation of the treatment plan. You have a right to contest any proposed treatment plan and have the court hold a hearing to decide what an appropriate treatment plan would be for you. If you successfully complete the treatment plan within the time allowed by law, your children will be returned to you if they have been removed from your care. If you fail to comply with the treatment plan ordered by the court, or you fail to comply with any other orders issued by the court in your case, you may be held in contempt of court and fined, incarcerated, or both. During the time the treatment plan is in effect, your children may remain with you or be placed outside your home. Your treatment plan may include counseling or therapy for you and your family. You may be responsible for some or all of the treatment plan costs depending on your income. Next, I'm going to explain to you what permanency means and what the law requires. If you have a child under the age of 6 and your child or children are placed outside your home, a permanent home must be found for your child or children within 12 months of the date your child was placed outside the home. If your child is over the age of 6 and placed outside of the home, A permanent home must be found for your child or children within 18 months of the date your child or children were placed outside of your home. If your child is not returned to you in that period of time, the Department of Human Services may file a motion to terminate your parental rights. If your parental rights are terminated, your child will be eligible for adoption by someone else. That's why it's so important that you attend every court hearing and do everything possible to successfully complete your treatment plan on time. If a request is filed to terminate your parental rights, you also have certain rights. You have the right to have an attorney represent you. If you cannot afford an attorney, and you financially qualify for a court-appointed attorney, one will be appointed to represent you at no cost to you. You have the same rights at this termination hearing that you have in a dependency and neglect trial, with some exceptions. At a termination hearing, your case will be heard before a district court judge or a district court magistrate. You do not have the right to a jury trial. Also, the Department of Human Services must prove its case to terminate your parental rights by clear and convincing evidence. Clear and convincing evidence means a firm conviction or belief that the condition which resulted in finding your child or children are dependent or neglected will in all probability continue into the future, and that under no reasonable circumstances can the welfare of the child be served by a continuation of that parent and child relationship. A failed treatment plan or your failure to comply with the terms of your treatment plan may be sufficient to terminate your parental rights. If you lose this termination proceeding, you have the right to appeal the judge's or magistrate's decision. The Department of Human Services is required by law to make reasonable efforts to keep you and your child or children together as a family, but only if your child or children would be safe. The court will decide if you and the Department of Human Services have both done enough to enable you and your child or children to live together safely as a family. If your child or children are under the age of 6, your case will usually be concluded within 12 months. If your child or children are all 6 years or older, your case will usually be concluded within 18 months. It's very important that you attend all court hearings. It is also important that you participate in and complete all court-ordered services to assist you and your family. If you ever have questions about what is happening in your case, or you do not completely understand something, do not hesitate to talk to your attorney, the guardian ad litem, or the caseworker. Thank you for your attention.
Wow, that was a lot of information that you just heard. Please remember the purpose of this type of case is to protect your children and keep families together whenever possible.
A few things that are of great importance to help you through this process are to show up to all your court dates and appointments, and to communicate with your caseworker and attorney if you have one.
And please be sure to ask questions about anything that you do not understand.
Best of luck.